Hello, this is the Law Professor channel. Today's presentation will address introductory issues in the law of tort, the law of tort. And the video has become necessary in order to give some context to some of the presentations that we've had in the past. We'll be looking at what do we mean by tort, what are the what is the historical context of the law of tort. We'll look at some policy considerations that can arise in tort. We look at the framework, the legal framework for the law of tort in Nigeria, and try to identify some similarities between the law of tort and some other disciplines of law like contracts, like criminal law. Typically, would be doing a PowerPoint presentation and to guide her discussion. The issue of tort law. I typically would introduce a class in tort law by letting students explain what what they understand by tort, and it is not um, unusual that they would not be able to explain. They would not be able to explain what is tort, unlike other aspects of tort law that you'd ordinarily have an inkling as to what it entails. So they would usually not be able to say, oh, this law governs this aspect of uh, life or the other. Therefore, the basic understanding of what we mean by a tort would be lacking. The word tort, therefore, needs to be explained, and then the context in terms of law would need to be explained. Um, to this end, we have the following learning objectives. We want to understand what we mean by the law, tort law. What does tort law do? Appreciate the social function of the law of tort. What is the role of tort law in society? We understand the policy implications of the law of tort, the presidential value, the legal framework, and the role of the judiciary in creating that legal framework in terms of understanding whether tort law is based on precedent case law, or whether it is statute, or whether it is both. So any introductory lecture should address this. While this video may not touch everything, but in any introductory lecture, you should get that kind of understanding. The other components of an introductory lecture should evaluate the implications of the law of tort on emerging social issues and problems. Because tort law is a law that deals with relationships, with human interactions, and therefore you'd want to find out how tort law evolves and how it develops and how it tries to meet up with what is happening in the society. So it is not a static system of law, it's a law that continues. However, whether the law is able to move at the pace at which society is developing is a different thing entirely. Um, so what is a tort? The word tort actually means twisted, from Latin word twisted. And as a legal framework, a tort is a breach of duty that the law has fixed. The law fixes a duty, and when you run foul of that duty, when you breach that duty, you are said to have committed a tort. So this is different from the law of obligations like contracts or other laws of obligation. Tort law is a breach of duty that that the law has fixed for you, and it's redressable by actions for unliquidated damages. Not fixed damages. Unlike contract law, for instance, and I will be emphasizing that difference as I get when I get to the point where we compare both frameworks. But in tort law, what we are saying therefore is that the damages that you'll be claiming in terms of what compensation you are claiming are not predetermined. They would have to be assessed by the courts when they are on their agreed, when the court has agreed that you have successfully put your case. Unlike if you have a contract for supply of a vehicle and then the vehicle costs 10 million naira. You know what the contract is about. You know the obligations under the contract. But in tort, that is not the case because there are usually no interactions between the parties to determine the framework of their relationship. Rather, the law has fixed these obligations, these duties, and they are hanging in the air. It's when one party runs foul of the duty that law begins to come into operation. And then the courts have to determine the framework for damages. So tort law is also called civil wrongs as against criminal liability, or like crime, that's in or like criminal law that deals with criminal issues. Tort law is about wrongs that are civil. So the framework, it does not, this does not belittle the significance of tort law, but it is a legal framework that deals with wrongs that are called civil as against the ones that are criminal and that have their own legal system. Tort law that we deal with in Nigeria is derived from the common law, but there are so many statutory influence. There are many statutes that impact the law of tort now, but essentially it evolved from English case law, and so you rely so much on judicial precedents. But there are some torts that have been, some of them completely overtaken by statutes. You have public liability legislation, you have workmen's compensations or employee compensation act in Nigeria, and when you do that, when you realize the implications of this uh, statutes, you know that sometimes because cases have to evolve, cases have to evolve and they take time to be decided in a lot of jurisdictions. Sometimes, therefore, courts, I mean, the legislature has to come in where there is a need to um, ensure that law meets up with some needs in the society. It is therefore imperative to understand that tort law has statutory flavor. So a tort is committed when a person breaches this duty that the law has fixed, defined as a civil duty, and is usually compensated by action for damages. That is what we call damages in tort law is monetary compensation. You'll be asking that the court pays you some money. Sometimes you're asking for injunction that you restrain, you stop the defendant from continuing to do a particular set of activities. Sometimes you can demand for an account of profit, especially in an action like the thought of passing off. You may demand for an account of profit if somebody has unjustly, illegally benefited from your economic uh, uh, your economic advantages. Now, the law of tort is therefore a law of relationship, a law of interactions, a social law, so to say, if I can put it in that context, at the risk of um, you know, at the risk of sounding a bit trivial, is a law that deals with how you behave, what you can do, and what you cannot do, short of being crime. So it's not the law that deals with crimes, but some of the thoughts that we have said, as we have said before, there is a relationship between thoughts and crimes. Now, historically, the law of thoughts that we has applied in Nigeria evolved and is as brought into Nigerian law from the law in English in England. It's a writ-based private law setting where you have to fit your course of action. If you have a claim, if you say somebody, for instance, has walked upon your land, has taken your property, has violated your person, you have to obtain a private writ. Like the writ can call it a form, and and fit your course of action. The forms are already designed. You complete the form, and if your action can fit into the questions, into the framework of this, of what we call a writ, then you have a course of action. And then the common law of England had two writs for the law of tort: the writ of trespass and the writ of trespass on the case, or what we call case. Now, the writ of trespass covered injuries to land or to goods or to persons, which were regarded as direct and immediate. Okay, the course of action, the interaction must be direct and must be immediate. Injuries that we call that are caused bare et amis in contra persimegris, that is, by force and harms acquired contrary to the king's peace. They are usually actionable per se. Injuries that are usually likely to cause a breach of the peace, what we normally call assaults and batteries now, you know, trespass to land, trespass to chattels, and what have you. These are things you do directly against the person, and if the person were to do self-help, and it might cause a breach of the peace. What we call two fighting, for instance. Oh, why did you take my dog? Why did you come to my property with my consent? Why did you why did you touch me? Don't these are things so that are direct actions. And actions on the case, the writ or regard concerning action on the case was for indirect and consequential injuries. And in these cases, you needed to prove damage. When you have the writ of trespass, it was actionable per se. There was no need to prove damage. But trespass on the case required that, action on the case required that you prove damage. So the thought today that we regard it as not actually per se, for instance, the thought of negligence, historically would have been fitted on the case. There are things that are indirect, that are consequential injuries. You did not actually interface with that person or property, but as a result of your actions, injuries have occurred. Or like a rate of trespass, which cover things like, a direct action. For instance, if A were to slap B, that is direct. That is direct. But if A was washing his car, and as he poured water uh, on the car, or let's take an example that is even a bit more in tandem with the society in which these streets operated, because there were no cars in the medieval times. Okay, so let's take an example where you walk upon the land, the farm of defendant walks upon the farm of the plaintiff. That is a direct act. That's a direct act. But if a defendant were to have a mango tree on his land, and the mango tree grows and the branches are overhanging into the property of the plaintiff, the defendant has not entered the property of the plaintiff, he has not touched the property, he has not done anything that, directly, but the result of what is taking place on his land is affecting the land of the plaintiff. So you have an indirect action. And you're talking about nuisance, for instance. You be talking of an action that is not actionable per se. And you have to prove uh, damages. And then in some contexts, these damages are actually infused in the course of action. When we take each tort, as you study each tort, you would see that sometimes these damages are infused in the course of action. Now, the framework in the 19th century regarding the fact that if you have a complaint, you just have to look for a writ that meets the complaint. Otherwise, you may not be able to bring an action in court. that framework is no longer the case now, because you don't have to fit your course of action into a particular rate, but rather what you need is the substance of the action. Now, these actually, in terms of if we were to go into the intellectual terrain, is also arguable, because if you look at some of your texts, some texts will write the law of torts, some will write the law of torts, plural. There have been arguments by various people, academia, judiciary, and whatever, in the decades in the past, about whether we are dealing with the law of tort or we are dealing with the law of torts. To say that you have the law of tort without, that is in the singular form, without an S, is to argue that there is a generic tort that once you can bring a claim and say that you have a wrong has been committed against you, you must this injury must be recognized. But some say we have some specified and identifiable torts, and so we have a lot of torts. And if this your course of action cannot fit into any of the identifiable torts, then you have no claim in law. We are not going to go into such arguments because it's beyond this presentation. But I just want you to have that at the back of your mind. And when you see some text, you see law of torts, some you see law of torts. And then you might wonder, was there an error or something? No, it's because it's a reflection of the ideological field to which the author subscribes. Um, Tort law is a very vast area. As we've said, it is the law that deals with civil wrongs. Actually, anything that represents civil wrong that is not premised on crime, on contract, is a law of obligations, but the obligations are fixed by law. The law of contracts is also a law of obligations, but these ones are fixed by parties, except for some, implied terms that you find in the law of contracts. So, therefore, it is a vast area of law, and because of the vastness of the area, it became impossible for you to have a to retain the law of tort in its traditional format and have a single text dealing with it. So you have it branching out into different areas. For instance, infringement of intellectual property rights, like copyright, trademarks, and patents are statutory torts in the strict sense of the word. They are statutory torts. The compensation for employment injuries, which you find under Workmen Compensation Acts, statutes, or Employment Injury Compensation Acts of modern countries like including Nigeria, are examples of tort that have branched out, you know, um, into independent frameworks, and you now study them as independent subjects. But because as long as there are wrongs that they are not based on contracts and they're just duties that the law has fixed, you can be rest assured that they are regarded as torts in the generic framework of tort law. The law of tort in Nigeria is based is a received law. We see the common law of England, the doctrines of equity, the status of general application. So it's a part of received English law in Nigeria. So we follow the judicial decisions in English law persuasively. Persuasively. They are not binding, but they are persuasive precedent in Nigeria. We also have Nigerian case law, that you can look at when you are studying the law of tort. But like I said, there are statutes that now uh, have influenced the law of tort, and they continue to do it. Sometimes it creates a completely new course of action. Sometimes a statute might, or a statute may repeal a decision. Statutes may also, in some context, um, amend areas of the law that are pro issues in order to give a faster mode of developing the law. And so in Nigeria, you'll be looking at a lot of cases with regards to tort law and statutes as well, with regards to some aspects of the law. And essentially, therefore, a student of tort law must be ready to read cases. Your cases are the ones that will guide you into the elements of the tort. In fact, some torts are named after cases. like the rule in rights, Rhinelander and Fletcher, that is a tort. To tell you how significant the case was, that is the tort. The tort in Wilkinson and Danton is named after a tort, after a case. So case law, don't shy away from it. If you don't like reading cases, you are not ready to study the law of tort. The principles will be elucidated from the cases, identified and analyzed. Policy plays a lot of role in the law of tort. You would find that in some cases where you would have found, because typically you would define when you are going to start taking your torts, your substantive torts. So you would have the tort being defined. When it is defined from definition, you have the elements that must be established. Extracted from that definition. And ideally, once you're able to identify and prove those elements, you should be able to have your um, wrong redressed. But there are some times when policy will play an important role in determining whether there can be a course of action in a particular field of law. And tort law is one aspect. So you would see, for instance, in the tort like the tort of negligence, that even when you are able to establish that there is a duty of care, there is a breach and there is damage, and therefore the person should have a cause of action in law, the court might say there is no cause of action because, for instance, they want to ensure that when they look at what can happen, if we say that there's a cause of action in this kind of a case, you would find that the court may have the foresight to see that it may create a floodgates of litigation. It may create challenges in a particular profession. So you have it in, for instance, negligence, liability for negligence, where there's pure economic loss, where there's negligent misstatement, where there is nervous shock, liability for breach of privacy, and many people, the jurisdictions have developed special rules in these cases beyond the general rule that there is a tort liability for negligence or a tort liability in one context. For instance, when it's been established in tort law that there is there is a duty of care that a driver has or owes to other road users. So you would think that every time any person that drives a car is on the road, the whole duty of care to everyone, the other road users. But where a driver was an armed robber and the other members of the gang were all escaping from the scene of a robbery, the court held that when the injury that those robbers, one of them suffered in the course of them getting away from the scene of robbery, could not be redressed in a law court because the court cannot append its name to a crime. So a criminal could not argue and say, even though I'm a passenger in that car, it was me. The court refused to allow that claim to stand. So policy is quite significant. Sometimes they would see and say, if we allow this course of action, do you know how many people will be suing this person, this defendant, and to cause a breakdown of the judicial system in one context? So many reasons have, over the years, as you study some thought, you will see the evolution of the thought and how the courts have refused to accept a course of action until they were certain to have developed some critical principles that would limit liability. Now, let's look at some relationships between the law of tort and other areas of law. Contracts. Contract is usually an agreement. People come together and agree to do something between them or amongst themselves. So there's always an agreement, a prior agreement between the parties. And when you bring an action for breach of contract, it's because one person has failed to honor one part of the agreement or the other. And in tort, there is usually no prior agreement. No prior agreement. You may not have met each other, but your actions has affected the other party, and that person feels that they should sue you. So there's not usually an agreement. Then the remedies are involved in contract differ from tort. In contract, you can have specific performance. That contract, you have to perform it. And then contract is reversible. If there's no specific performance, we can talk about also action for liquidated damages. You already know what you are claiming for. You specify the damages, that is the monetary compensation that you want, because you already have an agreement. Sometimes you have even specified it. If you do not honor this contract, this is what is going to happen. But because tort is not based on a prior relationship between the parties that is determinable, but rather fixed by law, you have tort actions are redressable by action for unliquidated damages. Okay, so we are not going to be able to take every one of the differences and similarities, but just the most fundamental ones to guide your understanding. And sometimes, the, the, in terms of similarities, there are some con, contractual breaches that are also tort. What you call fraudulent misrepresentation in contract is the same thing as the tort of deceit, for instance. Negligent misrepresentation in contract is redressable as the tort of negligence. And in some cases, the same act may be a tort and a breach contract. When you get to those torts, this will be explained. The tort and crime is another major discipline that can be compared. Most torts, and I mean, sometimes a tort may be inherently wrong, but not in all cases. It's not in all cases. Whereas in a crime is inherently a wrong course of action. Most crimes, let me say most crimes are usually things that will offend your sense of what is right or wrong. But in tort, sometimes what makes an action a tort is the way you did it. For instance, driving is not inherently a bad action. But when you overspeed and it causes damages, that injury that has you have, it can be a tort and can be a crime. So ideologically, you may say that most times torts may not necessarily be inherently wrong, but most crimes may be inherently wrong. But again, you have to take each of those torts or crimes and analyze them to see what exactly makes them a tort, what makes them a crime. Okay. Um, Crimes are regulated by the state, they are prosecuted by the state, they are defined by the state, they are a concern of the public. Okay, they are actions that are regarded as a violation, an infringement against the society generally, against the public generally. And in Nigeria, a crime must be written and penalty prescribed in written law. I'm sure Nigerian students will know that that is such a fundamental principle of law. The case of Aoko and Fagbemi has stated that, and it's been, something that generations of lawyers and students have come to understand. If you say something is a crime, they must show you the statute where it is defined as a crime and the penalty is prescribed as well. And in criminal in respect to tort, like I said earlier, torts are based on case law, and they are creations of the common law. They are not. Of course, if something is a statute, it means that it must be enacted into law by the legislature. But in terms of torts, most of the torts are common law. They are case based. In a crime, in a criminal system, you must prove a crime beyond reasonable doubt, whereas tort is proved upon a balance of probability, being a civil course of action. The criminal law system aims to, for not that's not the only aim, but it aims to punish the offender, to also deter others from committing a crime. But tort law is compensatory. The focus is to compensate the victim of a tort. And there are other, similarities and differences, but as time goes on, we would mention those in the course of other presentations. There's other similarities between tort and crime because some of the same set of facts can be both a tort and a crime. For instance, assault by false imprisonment, libel, uh, in some jurisdictions, conversion, which is is also regarded as stealing or theft. So some things that are tort are also crimes in the face of the of the law. In trust, breach of trust, tort is a common law action, as we've emphasized so far. Trust is based on equity, the development of the court of equity. A claim in the breach of trust is liquidated you know what you are asking for. It is fixed, it's predetermined, and is measured by the laws accruing to the estate. A claim in tort, as we've emphasized so far, is unliquidated. Um, in conclusion, therefore, we would say the law of tort is also called civil wrongs, and it addresses duties that parties owe each other outside of contracts, breach of trust, or other legal obligations. It is a civil wrong. It is addressable by an action for unliquidated damages. And the law of tort in Nigeria is based on the common law of England, interspersed with statutory flavor. We also have the precedents from local Nigerian cases that have developed over the years. But there are some statutes that affect tort law. There are significant similarities and differences between tort law, criminal law, contract, and other disciplines of law. And these differences would assist in the administration of all systems of law. Sometimes policy considerations come into play in identifying whether a cause of action arises or whether we should permit the particular plaintiff before the court to get a remedy. And the essence of all this in analysis is therefore to make us to understand the premise upon which any um, thoughts that you might be discussing flows from. If you therefore have to study a particular thought, for instance, you are taking the thought of deceit, you would know that they will give you a case for which it was um, uh, for which it evolved. The lecturer would give you the principles, the elements that is necessary for you to establish the thought. The lecturer would also give you the defenses that a defendant may raise in court. And it's usually the framework or the structure of the discussions in a taught lecture. In the subsequent videos, we would address some other introductory issues that assist you to understand the framework of tort law. Um, don't forget to subscribe to the channel, like the video, and share.